I'd like to introduce our guest commentator for this morning. His name is John Carro, and he's a civil trial attorney practicing in New York since 1982. John, let's talk a little bit about the very brief testimony we saw of the defendant in this case. He really didn't say much to this jury, but is it good for the jury just to hear him say, "I didn't do it"?
Well, I mean, it's good to put, juries like to see a defendant get on the stand. But in a case like this, where you have such a string of robberies and so many witnesses putting him behind, controlling the scenes, I think, and we heard from a juror, they expect to see more. There's nothing more than him saying no is no more than saying just not guilty. I really think there had to be some sort of explanation. This was very short. There was no dialogue. The jurors want to hear you talk. They want to get a sense of you as a person, not just saying no, 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 no. They're not getting a feel for him.
Well, it should have been then more of a narrative.
Absolutely. You want him to say his story. And what you really want is to say, well, why is it that all these people are blaming you if you didn't do it? What's the common thread? Why would they all want to get you? Did you once cross them? You did something to their parents? You know, that's what the jurors are probably really looking for, and one of the jurors gave a hint as to that.
And, you know, experts say that when a defendant, though everyone knows that the burden is always on the prosecution to prove the defendant guilty beyond a reasonable doubt, that when the defendant takes the stand, there's a subtle shift in the jury's mind of the burden, and there's a focus on the defendant's credibility, so that it's the downside in this case if he doesn't have much to say.
Right, because what happens is, what you always worry about is, and sometimes lawyers decide to leave well enough alone, because if you make one little gaffe, the jurors can take it and absolutely crucify you.
All right, we are going to go now to our case of the moment, and that